In the Garden of Eden, when Eve bit into the poisonous apple, bad things occurred for the human race. Likewise, I hate to say this, but if the Second Amendment community decides to argue that machine guns are protected arms under the Second Amendment in light of that decision by anti-gun, anti-Supreme Court Judge Carlton Reeves down there in the District of Mississippi, we in the Second Amendment community will be biting in to the poisonous fruit. Don't take the bait. Let's talk about this Carlton Reeves decision out of Mississippi and the potential dangers if it's appealed to the Fifth Circuit Court of Appeals and the issue of whether or not machine guns are protected arms under the Second Amendment. Let's break it down. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America at the 2025 Gundies Awards out there in Las Vegas. I appreciate all your support for allowing me to become the top voice of the Second Amendment among a very prestigious and crowded and excellent field of contenders for that award. I am greatly honored and privileged, and I hope I continue to earn your respect and support as we fight for our right to keep and bear arms throughout the rest of this year. All right, folks, so this is a video that's a follow-up video to a prior video I did several days ago involving a decision by Federal District Court Judge Carlton Reeves down there in the District of Mississippi dealing with whether or not a machine gun is a protected arm under the Second Amendment. In that case of the United States versus Brown, dealing with this question, Judge Carlton Reeves, who is no friend of the Second Amendment, who is no friend to Bruin, who is no friend of the U.S. Supreme Court, who's been on the record saying all of these things are basically bad and terrible, and the Second Amendment's terrible. That's basically his view. Nevertheless, he has played the role of the snake offering the poisonous apple, the poisonous fruit, to Eve in the Garden of Eden. Specifically, in this ruling that says that machine guns are protected arms under the Second Amendment, Judge Carlton Reeves is trying to thumb his nose at the Second Amendment movement and trying to get the U.S. Supreme Court to rule against our rights. It is a setup, and we in the Second Amendment community must not take the bait today in the year of our Lord 2025 and argue that machine guns are protected under the Second Amendment. Because as I pointed out in my prior video, and I'm responding to some comments about it, as I pointed out in my prior video about this decision, we 100,000% for certain will not win the case in the U.S. Supreme Court. And the reason why I feel the need to do this follow-up video, to really hammer home that we must not argue that machine guns are protected arms in the Second Amendment, and I'll tell you how to deal with this in a second, is because what court is Judge Reeves in when it comes to the Court of Appeals? In other words, what is the court to which an appeal shall be taken if someone takes an appeal in this United States versus Brown case, dealing with whether or not machine guns are protected arms under the Second Amendment? That is the U.S. Court of Appeals for the Fifth Circuit. Now, as a general matter, I really like the U.S. Court of Appeals for the Fifth Circuit. As a general matter, they're very good. We can all agree on that. They're probably the best court in America for the Second Amendment. We can agree on that as well. But here's the danger. As you may recall, it is the Rahimi decision where the Fifth Circuit found that Mr. Rahimi could not be disarmed despite his violent record, that gave rise to a cert petition to the U.S. Supreme Court, rushed at the time by Merrick Garland. And the U.S. Supreme Court reversed the decision in a very dangerous way. And what I mean by that is that the Rahimi case in the U.S. Court of Appeals for the Fifth Circuit that asked the question of whether or not a prohibited person, i.e. a person who was subject to a domestic violence restraining order after there was a finding that he was a danger to others, could be disarmed during the period of time of that domestic violence restraining order. The Fifth Circuit said no, he could not, which was a short-term sugar high win. But then the Supreme Court granted cert, heard the case, and reversed. Now, the good news is the reversal in Rahimi gave rise to some favorable language and some favorable information. So we lucked out there. That was great. But the point is, the Rahimi case, because of the terrible facts of a guy who was basically a guy engaged in like 4 or 5 crazy shootings, who had also hit his girlfriend's head against the dashboard or whatever it was a very dangerous case that could have backfired on the Second Amendment and created very, very bad precedent for the Second Amendment. We dodged a bullet there, metaphorically speaking, of course. So here's what I don't want to have happen, and then I'm going to break it down in greater detail. We absolutely do not want to encourage in the Second Amendment community arguments to the Fifth Circuit if this case is appealed. We do not want to argue that machine guns are protected arms under the Second Amendment, because if the U.S. Court of Appeals for the Fifth Circuit down there in Louisiana, Texas, Mississippi, if the Fifth Circuit were to buy into that agreement, to buy into that argument, and find that machine guns are protected arms under the Second Amendment, there will be a cert petition filed. The Supreme Court will undeniably grant that cert petition, and the Supreme Court 1,000% will rule that machine guns are not protected arms under the Second Amendment, which means we will 1,000% be 1,000% worse off if you have a Supreme Court ruling that says machine guns are not protected under the Second Amendment, as opposed to where we are now, which is a little bit loosey-goosey in certain respects. And moreover, in addition to the fact we clearly lose in front of the Supreme Court, we might even lose that case 9-0. It's possible we win it. If we do lose it, the best we can hope for is to lose 7-2. We might get Neil Gorsuch. We might get Justice Thomas. Maybe. But again, a 7-2 loss or a 9-0 loss means that for the rest of our natural lives and beyond, we will be living with a precedent that says that the machine guns are not protected arms under the Second Amendment. It is better to avoid that outcome. In addition to the fact that if they take such a case, that will be the Second Amendment case they take that term, as opposed to a term as opposed to a case that would be much better for us. So whatever we do in that Fifth Circuit case, do not argue or do not encourage, do not file amicus briefs, do not urge DOJ to argue that machine guns are protected arms under the Second Amendment. It is a terrible strategic mistake. Don't do it. Don't even think about doing it. It would be utterly stupid and terrible judgment, in my view. Okay, but let's go on. I also want to point out that in addition to a binding precedent that will be stuck with forever, that machine guns are not protected arms under the Second Amendment if this goes forward, and the Fifth Circuit rules in favor of the Second Amendment, beyond that, it is going to hurt us in our ongoing fight to get the Supreme Court to hear the AR-15 case and find that AR-15s, semi-automatic rifles, and magazines, and ultimately suppressors, by the way, are protected arms under the Second Amendment. Because here's the thing. If the Second Amendment community sends a clear message to the U.S. Supreme Court that a ruling in favor of AR-15s somehow will entail protections for machine guns, this is 100% going to reduce the likelihood that we're going to win on AR-15s, we're going to win on semi-automatic rifles and magazines and the like. So this is the harsh reality. And the reason why I mention this is the only way I can see capturing or redefining machine guns as protected under the Second Amendment is if you somehow abandon the in common use test, which we'll get to in a second. That's a very good test for the Second Amendment, and abandon that or loosen or do something else and argue something along the lines of, well, we need guns for a powerful military and we are entitled to military weapons. We're never going to win that. Or I don't say never, but we're not going to win that anytime soon with the current Supreme Court. It's just not going to happen. That is the harsh reality. We must be smart and not stupid based on our reality. Wishful thinking is not a strategy. And I'm telling you, if you try to get machine guns protected, it will 1,000% backfire on us. And not only will we lose machine guns forever, meaning there'll be a binding precedent by the Supreme Court that says machine guns are not protected, it will also hurt our ability to get what we possibly can get and should get, that AR-15s, that semi-automatic rifles, that AK-47s, that magazines, that suppressors are protected arms under the Second Amendment. We don't want to jeopardize that possibility until we win those cases and their precedents in our bag. But we're not there yet, so don't screw it up now. Beyond that, I also want to point out that you cannot screw up the Heller test. Specifically, it is crystal clear that the U.S. Supreme Court in 2008 in Heller said that if arms are in common use by Americans for lawful purposes, they cannot be banned. This is a fantastic test. It is clearly the right answer. I've written about this in multiple articles, both in the Harvard Journal of Law and Public Policy, as well as the Georgetown Journal of Law and Public Policy, and many other places. I don't think there's any real debate that I am correct. I don't think anybody would argue on the other side. And if they were, I don't know how they would do it unless you're an anti-gunner. Or you're foolhardy, in my opinion. The in common use test is a great test for, among other reasons. Remember, if you win the in common use argument that says an arm is in common use by Americans for lawful purposes and therefore it cannot be banned, that is sufficient for us to protect arms. It's not necessary. That may not be the only way we can win. And of course, it allows we, the people, to dictate and decide what arms we want, because if an arm is in common use by Americans for lawful purposes, it is protected. And remember, the burden of proof is on the government to show that a weapon is not in common use, because the in common use test is derived or extrapolated from the historical analysis part of the text first, burden shifts to the government. Government then has to engage in the historical analysis work. The in common use test derives from the dangerous and unusual principles derived and discussed in Heller, and therefore, because it's part of the historical analysis, the burden of proof is, of course, on the government, not on the Second Amendment proponent. And to the extent there's any debates about whether or not the in common use test is the law of the land, one just needs to look at 3 quotes from Bruin itself. Here's 3 quotes from Bruin that points out that the in common use test is the law of the land, and it's very good for us. Here's the first one from the U.S. Supreme Court in Bruin. After holding that the Second Amendment protected an individual right to armed self-defense, we also relied on the historical understanding of the amendment to demark the limits on the exercise of that right. We noted that, like most rights, the right secured by the Second Amendment is not unlimited. From Blackstone through the 19th century cases, commentators and courts routinely explained that the right was not a right to keep and carry any weapon whatsoever, in any manner whatsoever, or for whatever purpose. For example, we found it fairly supported by the historical tradition of prohibiting the carrying of dangerous and unusual weapons that the Second Amendment protects the possession and use of weapons that are, listen carefully folks, that are in common use at the time. Signed to Blackstone and the United States versus Miller. That is the U.S. Supreme Court in U.S. and NYSERPA versus Bruin in 2022. It's crystal clear. If a weapon is in common use, it cannot be banned. A machine gun will not be protected by the Supreme Court. So the best way to lose the machine gun case is this. You apply the Heller in common use test. You point out that 200,000 stun guns was effectively enough to protect stun guns in the Caetano case in 2016. So you argue that 200,000 stun guns is the apparent floor as to what's in common use by Americans for lawful purposes. You then point out that machine guns, if you look at the ATF data correctly, there's only 176,000 machine guns in civilian hands as of 1986, which is the year when the Hughes Amendment went into effect that said that you and I cannot buy brand new machine guns if we're not in the military, if we're not in the law enforcement world, or if we're not in FFL and with a particular manufacturing license, we can't buy that. And therefore, the right answer is 176,000 is below the 200,000 mark in Caetano, and therefore they're not in common use by Americans for lawful purposes. That is how to argue machine gun cases. You argue the methodology of in common use is the methodology under Heller. That is good. That should stand. And then you point out that machine guns don't meet that threshold because they're not in common use. This is how you lose machine gun cases today in a way that doesn't mess up the rest of Second Amendment jurisprudence. Personally, you know what I think? I like machine guns. I'm good with machine guns. I'm fine if people are allowed to machine guns. I have no personal problem with it. But I'm not here to blow, I'm not here to give you rainbows and unicorns and, give you wishful thinking and mouth the words, shall not be infringed, because it doesn't mean anything. It's worthless, okay? It's worthless in today's world. So this is the harsh reality. It's not a reality I necessarily love or like, but I'm not here to tell you what you want to hear. I'm here to tell you what you need to hear and need to understand, so you don't go out there and someone doesn't go out there and screw this up and make it all of a sudden now we're going to be fighting to our death, and now we're never going to get a precedent that says AR-15s and semi-automatic rifles are protected. That would be catastrophic. We don't want to be in a world And if you start pushing for machine guns, I'm telling you, we'll not only lose machine guns, we might possibly also lose AR-15s and blow up the in common use test, which is extremely good for us. And anyone who tells you otherwise does not know what they're doing. Period, full stop. That's my opinion, but I'm pretty firm on this. And if people want to blow up the in common use test, you're probably an anti-gunner and you're looking for ways to give judges excuses to disregard our Second Amendment right to keep and bear arms. To further support, I'm going to give you two other quotes to show you that the in common use test is the law of the land, both from Nysurpa versus Bruin. Here's the next quote. It is undisputed that petitioners Koch and Nash are part of the people, nor does any party dispute, in the Bruin case here, nor does any party dispute that handguns are weapons in common use today for self-defense. So again, more evidence that the Supreme Court understands that the test for arms ban cases in common use, that is the test, and it's good for us because it's going to protect magazines, AR-15, semi-automatic rifles, AK-47s, and suppressors if applied correctly. And those are big things we have to win next before we can even talk about machine guns. Here's the other quote from Bruin that reaffirms that in common use test is the law of the land, and we should not mess that up. Here's what they say. Drawing from this historical tradition of the prohibition on the carrying of dangerous and unusual weapons, we, the Supreme Court, explained there that the Second Amendment protects only the carrying of weapons that are those in common use at the time, as opposed to those that are highly unusual in society at large. And whatever the likelihood that handguns were considered dangerous and unusual during the colonial period, they are indisputably in common use for self-defense today. They are, in fact, the quintessential self-defense weapon. That's Nysurpa versus Bruin 2022. All right, to wrap this up, I want you to be very careful about this case out of Mississippi because Judge Reeves does not want us to win. He does not want us to have our Second Amendment rights. He does not want us to have guns. He is creating a trap for the Second Amendment. He wants the Fifth Circuit to affirm his ruling and say that machine guns are protected arms under the Second Amendment. So it will go to the U.S. Supreme Court, and the Supreme Court will water down the Second Amendment. It will water down the Nysurpa versus Bruin precedent. It will find that machine guns are not protected arms. That is what Judge Reeves wants. That is what the anti-gun movement wants. This is a trap. Do not take the bait. Do not support. Again, I don't hate machine guns. I'm just telling you, don't argue in court that machine guns are protected under the Second Amendment. If you have to argue anything, here's how you do it. As I pointed out earlier in this video, you argue that the proper standard is are machine guns in common use by Americans for lawful purposes? You then point out that 200,000 stun guns in Kaitana was sort of the threshold. Then you point out that a proper interpretation of the machine gun numbers based on the 1986 data of when the Hughes Amendment went into effect is 176, and therefore you simply point out that machine guns are not in common use by Americans for lawful purposes and they're not protected. Make that argument, lose that way, protect the methodology of Heller. Then you can go on and we in the Second Amendment community can push forward and hopefully ultimately prevail on AR-15, semi-automatic rifles, magazines, and suppressors, and AK-47s. We have to win those things next. All right, folks, so there you have it. Hope you learned a little bit something here today. I'll put a link to the United States versus Brown case down below and a couple other odds and ends. And make sure you follow me on X at @4boxesdiner. And don't forget to subscribe to YouTube and to Rumble, both channels. We're almost at 200,000 subscribers in YouTube. We're trying to get there, so we appreciate your support to get us over that hump. And I look forward to talking to all of you again very, very soon here at the 4 Boxes Diner.
Orders up. Table 2A.